ground.
I am simply adjourning the matter for a week, but I am making it very clear to all of you, all the respondents. Do whatever is to be done at your end. Otherwise, you're going to face consequences. This court will not take lightly non-compliance of these court's orders. Anything to be done at your end, kindly do it. Am I making it clear?
Lordship.
Yes, please.
On 12, Lordship.
Heard MS
Z. Jimom,
Jet Jimo,
Lordship.
Learned Counsel for the petitioner. Stop. Also heard Mr.
Mua Imchin, Your Lord.
Mwai
Mua Imchin.
Mua Imchi, Learned Senior Counsel, assisted by
No,
senior counsels are not assisted here.
no, I'm not a designated senior, Your Lordship. I'm a senior government advocate.
Oh, acha, acha. Senior Government Counsel and Mr. and so and so learned counsel for respondent number 2. Stop. It appears that the order of this court dated 14/2/2020 to the effect for considering and disposing of the application filed by the writ petitioner seeking compassionate appointment within a period of 2 months has not been disposed of till date. Stop. On the face of it, it appears that the respondents are acting in defiance of the order passed by this court. Stop. Be that as it may, let the respondents obtain instruction. Before be that you say, Mr. So-and-so learned counsel submits that the respondent number 2 has forwarded the application to the government of Nagaland for approval. Stop. Be that as it may, the order of this court being absolutely unambiguous is expected to be complied by the respondents strictly. Stop. However, before issuing any adverse orders, this court grants 1 week opportunity to the respondents to apprise the court as regards the status of the compliance of this court's order dated 14/2/2020. List again on Monday.
Lordship.
12th you want
Lordship.
on 12/11/2024.
Obliged, Lordship.
For admission, item number 3.
Yeah, please, Lordship.
Yes.
I'm seeking for 3 weeks' time
3 weeks time for what?
for there's certain developments. So
What development? This
I
is a
want to
contempt
seek-
petition.
yes, I want to
Which is the order against which you have filed
Lordship,
contempt? Where is that order?
order is at annexure A, page 16. Operative portion at the page 33.
Page?
Page 33 is the operative portion, and starting from page 16, annexure A. Judgment dated
Yes, please
order
read
dated
page 33, para 29.
Para
To
29.
constitute an expert committee to examine and determine the payment entitlement financial so-and-so. Expert committee should include representatives. The committee should be constituted as directed 3 weeks. The committee should complete the process of examining. So basically, overall 5 directions are there in the order. Yes, you are appearing for the respondents. Is this complied or not complied?
Lordship, I have filed affidavit. The expert committee has already submitted this report. Your
Because
Lordship.
it appears 5 directions are there,
Yes.
correct?
Yes.
Number 1, an expert committee has to be constituted. This has been done. Then the expert committee should include representatives from home and all this.
Yes.
This has been done. Then the committee should be constituted as directed within a period of 3 months. Has it been done within a period of 3 months?
Lordship.
And then committee should complete the process of examining the matter. That has been done.
It has been done.
And the recommendation shall then be forwarded to state government.
Lordship. And also to MHA.
Where do I get all this?
the report, your worship, in my affidavit, in
Page-
opposition, page 114, your worship,
Page 11.
114.
Page 114 of which affidavit?
My-
That lot of affidavits.
My affidavit, respond number 2, file on 6/9/22. Page 109, your worship.
One
Now here, your worship, what has happened?
affidavit filed by respondent number.
2 on 6/9/2023.
An affidavit of reply is already filed against this affidavit.
Lordship.
Where is the, one second, I got the reply, but I'm yet to get your affidavit. Yes, 3, 4,
Yeah,
where is 2?
Yeah, your worship, may kindly see, this is page 97,
1 second, page
97.
4 July 23.
Affidavit is.
No, page
Six-
97 is what?
Yes, 4 July.
Yes.
This is the report of the reconstituted expert committee. Why
Yes.
so this is the committee to examine, determine the payment and entitlement of the court. And recommendation is page 100. Recommendation of the previous committee. Your lordship, this initially what has happened, your lordship, expert committee was constituted, but that was during the pandemic, your lordship. And because of that, the representative from MHA could not personally be there to sit across the table with the committee, your lordship. So virtual arrangement was made, but because of poor networking, that also could not be done. So only
Ultimately-
letter was written. So what has happened, your lordship?
Ultimately,
Again,
it was reconstituted.
this honorable court has directed let the committee be reconstituted.
So it has
So-
been reconstituted and thereafter this
Yes.
committee on 4th July 23 had
Yes.
completed its report.
Yes, your lordship.
Terms of reference. Yes, what is wrong in this?
Your lordship,
You see, this is not an executing
Yes,
court,
Lordship.
correct?
yes, lordship, I'm well aware.
So the only thing, and you also have a very limited role when it comes to contempt proceedings.
Yes, Lordship.
Your role is to bring it to the notice of the court
Yes, lordship.
that such and such order of the court has not been complied.
Yes, lordship.
Thereafter, it is between the contemptor and the court,
Yes, lordship.
correct?
Amma.
Now, the contemptor has filed its reply.
Yes,
It
Lordship.
appears that because of some pandemic issues, perhaps that constituted committee could not do its part within the time that has been stipulated. Thereafter, court has given them time to reconstitute. It has.
No, your lordship, the thing was, there was a finding by this honorable court saying that it was not complied with. There is an order to that effect. The judgment and order of this
Your
honorable
Lordship,
court. So it was reconstituted. However, the second reconstituted expert committee only reiterated the
No, you see-
findings
You see, Mr.
of the
Counsel,
first.
Mr. Counsel.
Yes, Lordship.
In case you have some grievance against the reconstituted committee report, your remedies are open.
Yes, lordship.
Your remedy is not before this court.
Yes,
Because
lordship.
before this court, the question is about willful, deliberate non-compliance. Correct?
Yes, lordship.
Initially, also an expert committee has been constituted.
Yes, lordship.
For some reason that could not done. Now they have reconstituted. The reconstituted one has submitted his report. You may have certain grievances as regards that report. According to you, it is not done correctly, right?
Yes, lordship.
Yes, so but you take up that issue before the appropriate forum. You
Lordship,
you have the liberty.
yes, lordship, I'm well aware of that.
Yes.
However, the petitioners are, I have certain these things. new developments have come up.
How can new development come up in a?
Your lordship,
contempt proceeding?
if the matter can be listed after 3 weeks,
No, the
if-
question of granting time doesn't come, Mr. Counsel, because the issue is very narrow.
yes, lordship, I'm
Compliant,
aware,
non-compliant,
lordship.
right?
Yes, lordship.
Non-compliance, willful or willful, deliberate or unintentional. That is all.
Yes, lordship.
Now it appears on the face of it, everything is done. The outcome may not be satisfactory to you. That is not the, that is not something that this contempt court can go into.
Yes,
isn't
lordship,
it?
but willful,
I'm
there may
closing
not be your willful, but partial compliance may not be full compliance of the judgment, your lordship.
Done.
Lordship, if
If
a
you
short
point
time can
out
be,
that one of the direction is not done, then I can give you time, but that is not the thing. You want to bring some further developments.
yes, lordship.
And isn't it?
On this matter only, in the contempt only, your lordship, the direction was for determination of the lordship, if I may be
Yes,
allowed.
yes, please.
The 29, paragraph
Yes, I
29.
am. I'm
lordship.
in para 29.
Page 34, the last portion.
Yes.
From the top, certified copy of this order, and the committee should complete the process of examining the matter of enhancement of the honorarium and other allowances of the wages as expeditiously as possible and not later than within a period of 4 months. Your lordship, the direction is for determining and examining, your lordship. However, what has happened was that before determination and examination of the matter, the government has written to the MHA before the expert committee was constituted. So the expert committee was biased from the beginning.
See, Mr. Counsel, these are things which you have to agitate before the writ court, not before the contempt proceeding.
If I may be allowed 3
You-
weeks time, your
No,
lordship,
no, no.
I have certain instructions from my clients.
You can
They were-
file a fresh petition, not in a contempt proceeding. You cannot take up these issues in a contempt proceeding.
Yes, lordship.
You see, I have my empathy with you.
Yes, lordship.
I'm not saying what you're saying is not right.
Yes, lordship.
Maybe they were biased.
Yes, lordship.
But how can a contempt court go into this? What
If-
is contempt?
Yes, I'm aware of that also, your
Then-
lordship.
Then why unnecessarily keep this matter pending?
If the matter can be listed after 3 weeks,
No, no.
I'll seek
What
instructions.
will you do in 3 weeks, Mr. Counsel?
Certain developments are there.
Developments, I'm reiterating again and again. How can you bring developments before the contempt court? Any developments and you have some grievance, you agitate.
Yes, lordship,
Your doors are open,
yes, lordship.
open them. Have you followed what I'm saying?
Yes, lordship, I'm following. Lordship,
Because you see, come to page 100, this recommendation by the E-Constitute Expert Committee, please read. And A is recommendation of previous expert committee.
yes, lordship.
B is recommendation by the reconstituted. Read.
Yes,
It
lordship.
appears they have done whatever is required to be done. Please read.
Yes, lordship. Grant of rewards and awards for heroic deeds and achievements to those VGs on duties as acknowledged, which should be specific to law and order duties and assignment, including ex gratia. As the CMHIS has been introduced and is being implemented in the state from 2022, to which the VGs are also entitled to and are availing the scheme. As for the pay and allowance of the VDF in other states, a detailed discussion was held after obtaining the guidelines on the roles, duties, and functions, perks, and allowances being offered to the VDF in Manipur. After much deliberation, the House came to a conclusion that the roles, duties, and functions of the VDF in Manipur and the VGs in Nagaland are quite different, and hence payment of honorarium to the state VGs equivalent to that of VDF in Manipur is not possible. The members of the expert committee were of the opinion that the basic demand of the VG association relates mainly to enhancement of honorarium of the village guard, which is being paid by the Ministry of Home Affairs government. The views and opinion of the members, including that of the representative of the VG association and especially that of the Ministry of Home Affairs Government of India, which pays the honorarium of the VGs, wherein they stated that.
Not recommended at this juncture.
Yes, Lordship.
See, I understand what you're saying.
Yes, Lordship.
It seems they have reiterated the first
Yes, Lordship.
committee, but whatever, these things you can agitate before the appropriate forum. All right. Okay, please take it up.
If I may have a small submission, Your Lordship.
Yes,
If Your Lordship is
give you that liberty.
yes, Your Lordship, to give me that liberty so as to agitate my grievances before appropriate forum.
I'm not promising anything at this moment. Let me dictate. I will see the flow of the order because I am when it comes to contempt, I am kind of conservative because according to me, the contempt court cannot do anything beyond what is given in the statute. The only thing that the contempt court can do is punish in case of compliance. That's it. This is not an executing court, but be that as it may, let me see. Let me dictate the order first. This is item number
Three.
three for disposal. Huh? You are Mr.
Arin Long, Your Lordship.
Huh? Okay.
Arin Long.
Arin Long, right?
Yes, Lordship.
Heard Mr. Arin Long, learned counsel for the petitioner. Stop. Also heard Mr.
TB Jamir.
TB Jamir, learned counsel for respondent number
2.
Respondent number 2.
My-
Mr. I.
LT Sanctum for
LT
Sanctum
for respondent number
7 and 8.
7 and 8. And Mr.
N. Angami for respondent
A.
number 1.
Agami
For
for
respondent number
respondent
1.
number 1. Anybody? All respondents?
For
Mr.
Mr. Lordship, I'm for the respondent then.
Mr.
I bring information. C Pom, Your Honor.
C.
C Pom, Your Honor.
For respondent number?
Respondent then. I bring from my
Okay.
senior. Yes, Your Honor.
Anybody else?
Lordship, in team song for respondent number 4 to 9.
So and so for 4 to 9. So all respondents represented?
Lordship.
Just see 1 to 10, I think. All are represented. Anyone for 3? For 3, anyone? If just give the name.
Lordship.
All right.
Lordship.
By filing this application under section 11 and 12 of the Contempt of Courts Act 1971, read with Contempt of Courts within bracket Gauhati High Court, Rules 1977, and Article 215 of the Constitution of India, the petitioner is seeking initiation of civil contempt proceedings against the respondents for alleged violation of the judgment and order dated 29/1/2021, passed in WA number 1 within bracket K/2018. Stop. The facts of the case is that the petitioner had filed WPC number 33K of 2017, seeking enhancement / revision of their pay on the ground of equal pay for equal works, which was allowed by the learned single judge by judgment and order dated 19/11/2017 in WPC. Sorry, that is already there. Stop. Being aggrieved, the state government had filed writ appeal being WA number 1K of 2018 against the aforesaid judgment and order of the learned single judge. Stop. The learned division bench by judgment and order dated 29/1/2021, modified / set aside the judgment and order of the learned single judge dated 19/11/2017, passed in the aforementioned writ proceedings, with the direction to constitute an expert committee within a period of 3 weeks.
3 months.
3 months, and the committee should complete the process of examining the matter of enhancement of the honorarium and other allowances of the VGs as expeditiously as possible
I'm sorry, your lordship, I stand corrected.
and not later than within a period of 4 months from the date it is constituted. Stop. That 3 months should be 3 weeks.
Lordship, I'm so sorry, your lordship.
Councils, in case you want to say something, just take a note and say it after I finish. Otherwise, it breaks the flow.
Lordship,
Please
I'm
take
sorry.
your seat now.
Sorry,
No
your
problem.
Sorry. Your lordship.
I can understand the anxiety. I was also other side earlier. Now you take your seat. Let me first finish the order. Despite the petitioner approaching the respondent authorities by filing various representations, since the order of the court was not being implemented within the time frame fixed by this court, the contempt proceeding has been filed. Correct? Stop. Mr. Aringlong, learned counsel for the petitioner, submits that though a revised expert committee has been constituted and a report has been submitted, however, the same is biased and not in strict compliance of the order passed by this court. Stop. That's your submission, isn't it? All right. Per contra, Mr.
TB Jamir.
TB Jamir, learned counsel for the respondent, contender number 2, submits that the reconstituted expert committee has examined the issue and passed and recommended in accordance with law and in strict
And made recommendation in terms of the direction passed by this noble court.
and in terms of the direction passed by this court by order dated 29 2021. Stop. He accordingly submits that the order of the court being complied, nothing survives for adjudication in the present contempt proceeding. Stop. Next para. I have given my prudent considerations to the arguments made by the contesting parties and have perused the materials available on record. Stop. Apt to refer to the direction given by this court by order dated 29/1/2021, which is against which the present contempt petition has been filed. Stop. Paragraph 29 of the aforesaid judgment and order is reproduced hereunder for ready reference. A to A, page 33. Yes.
Yeah, please, your lordship.
Yes.
I forgot to mention one more submission,
yes,
your lordship.
yes.
In the affidavit filed by the respondent number 2 at page 97, your lordship, after the first expert committee was constituted and affidavits were filed, and this court by order dated 5/12/2022, there was an order passed. And
5/12?
5/12/2022.
Hmm.
And in pursuance to this honorable court's direction,
The second committee was
second committee was
All right, all right,
constituted,
all
your
right.
lordship, reconstituted, your
All
lordship.
right, I'll mention that. This order is
5/12/2022, your lordship. Page 97.
no, it must be in the
Yes, lordship.
I've taken your lordship to the reconstituted committee.
where you have said submission of the petitioner lawyer, no, erring law. In the submissions of erring law, please add one more submission.
That it is also in.
Put a star and you say.
Not in compliance to the order of this.
He further submits that this court earlier on 5/12/2022, upon examining the report of the first expert committee, Tracy, what did you write? He further submits. No, upon coming to the opinion that the contents of the minutes of the meetings of the first expert committee not being strictly in terms of the direction given by the court against which the contempt petition has been filed, directed the respondent number 1 to reconstitute the committee in the light of the submissions made by Mr. T.B. Jamir and the other counsels representing the other parties within a period of 1 month from that date. Stop. He further submits that the current report of the reconstituted expert committee is also not in the line of the direction given by this court in this contempt proceeding by order dated 5/12/2022. Stop. Okay. Now go towards the end, huh? It appears that in pursuance of the direction given by the division bench, the government of Nagaland by notification dated 14/4/21 constituted the committee consisting of the following persons. 1, 2, 8. You will get this in this green flag. I'm marking star. B to B. I'm putting star mark and I'm saying B. B to B. Then in the notification, the terms of reference was given as under 1, 2, 3. Same page continuation. And from that, you may also write paragraph 4. I have said D. D to D. Okay. It further appears that this court earlier, when the matter had come up on 5/12/2022,
Your Lordship,
hearing the
may I have interrupt your lordships? Your Lordship, I'm led by my senior in this case.
Mr.
So
Counsel, please don't interrupt unnecessarily. Please
If-
take your seat.
if the matter
I'm
can be listed
dictating the order, please take your seat.
on Thursday, Your
I'm going to
Lordship.
reiterate what I'm saying. Please take your seat. Yes. It is very unfortunate that councils interfere so much when an order has been given. It is actually you're obstructing the administration of justice. You yourself is filing a contempt petition and you're trying to do the same. Please don't disturb when a judicial work is being done. What did I write? Upon hearing the counsels and examining the contents of the minutes of the meetings of the first committee, was of the opinion that the same is not in accordance with the direction given by this court. Stop. However, this court, upon observing that the state respondents has taken some steps and they have not deliberately ignored or neglected compliance of the directions given, comma, directed reconstitution of an expert committee by the respondent in the light of the directions passed earlier by this court. Stop. Paragraph 8 and 9 of the aforesaid judgment and of the aforesaid order dated 5/12/2022 passed by this court in the present contempt proceeding is also reproduced hereunder for ready reference. E to E, para 8 and 9. All this you will get that in that green flag star. Stop. What transpires from the above is that this court had already observed that the respondents are not deliberately or intentionally sitting over the matter. However, the minutes of the first expert committee being not in accordance with the direction passed earlier, this court directed reconstitution of a second expert committee. Stop. It appears that pursuant to the aforesaid direction of this court, a second committee was reconstituted.
Page 64 of my application.
And the same, and the said committee has submitted its report on 4/7/2023. Stop. The members of the reconstituted committee are as under 1 to 8, page 97. Another second star, number 2, 1 to 8. I've tick mark it. The terms of reference of the second expert committee are as under 1 to 1 to 4. Accordingly, the second committee examined the matter upon thorough discussions and decisions and recommended as hereunder. At page 100, recommendation by the reconstituted expert committee, quote unquote. B, tick mark it. A perusal of the said recommendation of the second committee appears that the order of this court is complied. Stop. That being so, nothing survives for adjudication in the present contempt petition. Stop. The submission of the learned counsel for the petitioner as regards the biasness and the findings of the committee being not in accordance of the orders passed earlier by this court are matters beyond the jurisdiction and power of a contempt court. Stop. It is a settled law that once the petitioner brings notice of an order being not complied, thereafter, the matter is between the contemptor and the court. Stop. The contempt court is not an executing court. The contempt court, if upon the show cause being filed by the contemptors is satisfied that the orders of this court has been complied, nothing more is required to be gone into. Stop. As stated above, this court is satisfied that the directions given by this court by order dated 29/1/2021 stands complied at this stage. And hence the contempt petition fails and hence the contempt petition stands closed. Stop. It is needless to be clarified that in the event the petitioner is aggrieved by the recommendation made by the second expert committee, he is at liberty to approach the appropriate forum in accordance with law. Contempt petition stands disposed of.
Oblige.
I'll resume in 5 minutes.
For admission, item number 4.
May it please, Your Lordship. Lordship, I have instruction to appear on behalf of the newly impleaded respondent number 3 and 4.
And item number
4.
all right.
So Lordship,
File your response, return.
Lordship, today I've entered appearance
I
on
know.
their behalf. Then can you grant 3 weeks time to
Yes,
obtain
yes, I've
instruction?
already said it.
Yes. 3 weeks to obtain
MS.
instruction. We shukriya, Your Lordship.
So and so learned counsel enters appearance on behalf of the newly impleaded respondent numbers 3 and 4.
Yes, Lordship.
Stop. She further seeks
3 weeks.
3
Your
weeks
Lordship.
time for filing return in the matter. Prayer is allowed. List this matter after 3 weeks on a date to be fixed by the registry.
Much good.
For admission, item number 5.
May I please, my lord?
Yes.
I for respondent number 2 to 4, lordship.
Yes.
Your lordship state is contempt to file appeal. So can you grant 3 weeks time?
Mr. Counsel, I shall not grant you time for filing appeal, but I can grant you time for filing your return
Lordship,
because this is a contempt proceeding.
lordship.
You want to file appeal, you file extension application before the court in the matter where that order has been passed.
Lordship.
I am not going to give you that
Lordship,
extension
oblige,
here.
Lordship. Kindly grant us three.
Appeal, no appeal is your prerogative. You
Lordship.
can do whatever you want to do,
Lordship.
but the orders of this court has to be complied.
Oblige, Lordship.
Your name?
K. Angami, Lordship.
Mr. K. Angami, learned senior government advocate, seeks 3 weeks' time to file response in the matter. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registry.
Oblige, Lordship.
For admission, item number 7.
Yes. What is this 227?
May I please, your Lordship?
LCR is still awaited.
Yes, no. It's available, Lordship.
LCR has come.
Yes.
She has come.
Lordship,
Yes,
I pray that this matter may be fixed for hearing after 2 weeks.
all right. It appears that the LCR has been received in the matter. This is in the admission. I'll fix it for hearing, admit it and fix it for hearing.
Lordship.
Yes, Lordship.
Matter requires a full-fledged hearing. Admit, list this matter, admit no formal notice as respondents are already represented. List for hearing in the month of December on a date to be fixed by the registry.
Oblige, Lordship.
For admission, item number 8.
May I please, Lordship, we have complied with the court order and we have paid the pending bills to the petitioner. So I pray that the matter may be closed.
Yes,
Yes, your Lordship, we have received it.
all right. Heard MS
Shisa Jamir, your Lordship.
Jamir, C Jamir,
Shisa Jamir.
Sisai,
Shisa.
Shisha, Jamir, learned counsel for the petitioner. Stop. Also heard MS V
Shukriya.
Sokri,
Yes,
learned additional advocate general,
yes, Lordship.
appearing on behalf of all the respondents. Stop. It is submitted at the bar that the order against which the contempt petition has been filed has been complied by the respondent authorities during the pendency of the contempt petition. Stop. MS so-and-so, learned counsel for the petitioner, submits that the bills, that the bills of the petitioner has been
Paid.
has been paid as directed by this court. Stop. Accordingly, nothing survives for adjudication. Contempt petition stands closed.
Okay, much obliged.
Oblige, your Lordship.
For admission, item number 9.
Here also, the Lordship, similar.
Same.
Yes.
So
Lordship.
item 8 and 9 both disposed of, huh?
Mm.
Lima? Both disposed of. In item 9 also, same order, I think.
Lordship,
Same order.
much obliged.
Uh,
The writ petitions are different, your Lordship.
Writ petition are different.
Yes.
Okay.
Mm.
Marshal, just writ petition numbers, you check and write it, okay? You put it with the file to me. All right,
Okay,
disposed
that's-
of.
For admission, item number 10.
Yes, what quashing you want?
Lordship, question of FIR and.
FIR.
Yes, Lordship.
This has come up for the first time? No. Yes? Respondents,
For state responses, Lordship.
where is the FIR?
Lordship, FIR is in page.
So there is a
9,
compromise
page
deed.
Yes, Lordship.
What was the offense? 354.
354 CIPC, Lordship.
And is this a joint application?
No, Lordship.
Anyone appearing for the respondent number 2?
Your Honor.
You have any objection?
No, Your Honor. No, Your Honor. Yeah.
Compromised?
Yes,
Yes.
Your Honor.
Matter has been compromised?
Yes,
Yes, Your
Lordship.
Honor. Moreover, I have given a withdrawal complaint to the CGM
You have already withdrawn or you have filed an application for withdrawal?
application for the withdrawal, Your Honor.
Where is the compromise deed?
Lordship, it's in page 27.
Page 27.
Yes, Lordship.
All right, Marshal. This is item number 10 for disposal. Heard MS
Nalhevolu.
Nalhevolu, right? Cause list. Stop. Also heard
Kia Angami,
Mr. K. Angami,
PP.
Learned PP. How many PP do you have here?
We have five, Lordship.
5 public prosecutors,
Lordship.
not APPs,
No,
all PPs.
Lordship.
Learned public prosecutor for the state, Mr.
Kiki.
Huh?
Kiki.
K.
Kiki.
Spell it.
KIKHI.
Learned counsel for respondent number
2.
2. Within bracket, informant. Correct. By this application under section 482 CRPC, the petitioner is seeking quashing of the criminal proceedings lodged against the petitioner accused in GR 125 of 2022 under section 354 within bracket C IPC in relation to case number 006 of 22 Khuzama PS. Stop. The basis of filing the present quashing proceeding is the compromise deed, which has subsequently entered between the complainant stroke respondent number 2 and the accused petitioner. Stop. The said compromise deed as enclosed as Annexure C to the revision petition is reproduced hereunder for ready reference. A2A, page 27. Perusal of the aforesaid compromise deed indicates that both the parties has entered into an amicable settlement, and in pursuant to such settlement, the complainant has already filed withdrawal letter on 29/7/2024 before the trial court. Before the trial court.
Your Honor, Chief Judicial Magistrate.
Before the jurisdictional Chief Judicial Magistrates Court for not pursuing the case on the basis of the aforesaid amicable settlement. Stop. Mr. So-and-so, learned counsel for the complainant informant, further submits that the matter has been resolved and he has instructions from the complainant not to, and he has instructions from the complainant to withdraw the complaint lodged against the accused petitioner, to which he has already acted by filing appropriate withdrawal application before the jurisdictional Chief Judicial Magistrate Court. Stop. Correct. In view of the aforesaid endorsement and the compromise deed as referred above, this court is of the opinion that this is of the opinion that in view of the compromise arrived between the complainant and the accused person, further continuance of the criminal proceeding against the accused person shall not be justified. Accordingly, the accordingly, the criminal proceedings being GR 125 of 2022 corresponding to Khuzama Police Station case number 006 of 2022 registered under section 354 CIPC and charge sheet number 006 of 2023 dated 7/7/2023 stands quashed. Stands set aside and quashed. Okay, disposed of.
Please.
Much obliged.
For orders, item number 11.
Yes, some dusty.
Lordship.
You're entering appearance?
Yes, Lordship, first time, Lordship.
You are for respondent number?
2 and 3, Lordship.
And what about one?
And for stating.
One. So all respondents are now represented. So you file your, I'll enter your appearance and you wish to file something?
Lordship, yes, complies to this petition, Lordship.
This
It's
is
already been compromised.
compromise?
Yes, Lordship.
Yes, Lordship. This is for quashing.
Yes,
of
but is
FIR.
compromise,
Yes.
respondent is saying, where
Yes,
is the
it is
compromise
compromise.
agreement? I can dispose it of them.
Page number 17, Your Lordship.
Page number 17 and the translated copy is in page number 18. And Lordship, the complainant has also written and
Withdraw, I
Withdraw-
withdraw my FIR, Lordship.
Withdraw.
visual, yes,
Yes.
visual of FIR.
So it will be similar to the earlier order.
Lordship.
You are for the complainant, right?
Lordship, Lordship.
And the withdrawal is page 19.
Yes, Lordship. Yes, Lordship.
Item 11, that's right. Third, MS
P. Mombini Izung.
P. Mobini Izung, learned counsel for the petitioner, stop. Also heard Mr.
Metovero.
MEDO, na?
Yes,
Mido Vero
Lordship.
for learned counsel for respondent number 2 and 3 within bracket complainant.
Lordship.
And Mr.
Yeah, Angami, Lordship.
K. Angami, learned
PP, Lordship.
learned PP for the state. Stop. By this application under section 482 CRPC, the petitioner is seeking quashing of the criminal proceedings against the accused person in GR 127/2023 corresponding to Gauhati PSC number 03 of 23 registered under section 107, 110, 320, 325, 329, 341, 34 IPC. Stop. It is submitted by the MS P. Moveni Izung, learned counsel for the petitioner, submits that the current application for quashing of the said proceeding has been filed in view of the compromise arrived between the parties, which is recorded in the agreement dated 10/1/2024, enclosed as annexure B1 to the criminal revision petition. Stop. Mr. Midovero, learned counsel for the informant, concedes to the aforesaid compromise arrived between the complainant and the accused person, and further submits that in pursuance to the aforesaid compromise, the complainant has already written a letter to the jurisdictional police, to the jurisdictional investigating officer for withdrawing the FIR lodged against the accused petitioner. Stop. I have heard and perused, give all that. Then you say, apt to refer to the compromise agreement, which is reproduced hereunder for ready reference. A2A, page 18. It appears that the complainant and the accused persons in the presence of the village elders have compromised the matter, and in pursuance of such compromise, the complainant by letter dated 12/1/2024 has requested the officer in charge, Gauhati Police Station, Junikoto, Nagaland, for withdrawing, to withdraw the FIR which has been lodged against the accused petitioner. Stop. Relevant portion of the aforesaid letter is also reproduced hereunder for ready reference. B2B, page 19. Next, in view of the endorsements made by the learned counsels for the parties and in view of the compromise and the compromise arrived between them, comma, this court is of the considered view that further continuance of the criminal proceeding against the accused petitioner is not justified. Stop. Accordingly, the FIR dated FIR dated 21/12/2023 in GR number 127/2023 corresponding to Gauhati PS case number 03/2023 registered under section 107, 113, 320, 325, 329, 341, 34 IPC stands set aside and quashed, disposed of.
Much obliged, Your Lordship. Lordship, I may be allowed to seek my Lord's indulgence. Item number 10. By date order dated 27/9/24, LCO was called for. So if that may be
Returned?
Yes, correct.
All right. In item 10, did you take return LCR just at the end? Thank you.
Obliged, Your Lordship.
For orders, item number 12.
LCR has come. In item 12, has the LCR come?
May it please your lordship.
Has the LCR come?
Still awaited, my lord.
So await LCR.
Yes. Your lordship, here,
Hmm.
the present petitioner had approached the state respondents in this disputed land by order dated 4/7/2024. The Deputy Commissioner Kohima has passed judgment and order. Against the judgment and order passed by the Deputy Commissioner Kohima, the present petition has been filed. So whether the trial court,
Mr.
the
Counsel,
DC,
there is a
DC who acted as
Yes,
a
Mr.
trial court
Counsel,
can be
I am
impleted.
what you are heading to. But
Yes,
there is a
ma'am.
judicial order whereby the trial court records have been called.
Yes, ma'am.
Now it is still awaited. So
Yes,
I don't think today there is anything much to be done. Let the records be available because there is a judicial order. I cannot ignore the judicial order.
Yes, ma'am.
And take up the issue of maintainability. Perhaps you are trying to raise a maintainability issue.
Yes, ma'am.
You are open to raise it.
Your lordship, here, since the state respondents had acted as a trial court, whether they can be impleted as respondents in this case.
We'll look into these issues later on. You take up these issues, let the records come. Await trial court records, list after 3 weeks on a date to be fixed by the registry. In the meantime, registry is directed to send a reminder.
Much.
Your lordship, there's an interim.
Interim, if any, shall continue till the next date of listing.
Much obliged.
For orders, item number 13.
Service completed?
My lord, by order dated 29/2024, I was asked to
Yes.
to substitute notice, yes, my lord.
Publication?
I'll be filing that affidavit
All right.
within a week, my lord, so I may be allowed a week's time.
Mr. Taka Kichu?
Kichu, yes, my
Mr.
lord.
Taka Kichu, learned counsel for the petitioner, seeks 2 weeks' time to file the requisite affidavit of service.
My lord,
Prayer allowed, list after 2 weeks on a date to be fixed by the registry.
my lord, there is an interim.
Interim, if any, shall continue till the next date of listing.
Much obliged.
For hearing, item number 19.
14 is adjourned. Compassionate appointment.
Lordship, my blessed Lordship, Lordship, as per the earlier order, I was instructed to produce 2 documents by way of affidavit. And Lordship, yesterday evening, I have received, so a short time may be given.
That is
To file
one
my
thing,
affidavit,
but
Lordship.
when did you are seeking compassionate appointment for whom? Who died and who's applied?
The petitioner father, sir,
Father, when?
2008, your Lordship,
2008.
8,
And when did you apply?
2013, your Lordship,
2013. You've applied after a delay of almost how many years? 13, from 8 to 13 would be about 3 years?
Lordship.
No, more than 3 years. Yes. Now tell me how your application is maintainable.
Since Lordship, the petitioner is a non-indigenous inhabitants of the state.
Mr. MS State Counsel, this court is asking a question to the petitioner as how her application is maintainable.
Lordship, my apologies, Lordship.
Are you saying there is some policy here for this is relating to providing employment?
Lordship,
Huh?
Lordship.
What? There is some scheme.
Yes,
You see why I'm asking this question. Are you aware of the decision of the Apex Court in Debabrata Tiwari's case? You're not aware.
Lordship.
Where is the application?
Annexure 3, Your Lordship.
Annexure,
3,
page,
page number 25, Your Lordship.
page
25.
25. See, I am prima facie of the opinion that this writ petition is not maintainable on the ground of delay. Admittedly, the father of the petitioner died on 2008, correct? And you have filed your application in 2013. Page 25.
Yes, Your Lordship.
That is some land, Nagaland police manual. Where is your application? I think page 27.
Your Lordship, my senior, he's leading this case. If it can be listed after a week, Your Lordship.
No. Your senior may be leading, but you are appearing in this court. You are also competent. What is this trend of trying to get the matter adjourned when you see that the matter is going against you? You must be able to convince the court. These are opportunities which you need to grab. You see, Miss Counsel, the hurdle in the way of the petitioner to get the relief as claimed is the decision of the Apex Court in the case of State of West Bengal versus Debabrata Tiwari. In that decision, the Apex Court has clearly held that belated applications or belated matters as regards compassionate appointment, no matter whose fault it is, it could be the fault of the petitioner or the respondents, for the respondents having not considered it for many years. But no relief can be given for the simple reason that compassionate appointments are given as matters of immediate relief. Now, when there is a delay of more than 2, 3, 4 years, the sense of immediacy gets frustrated, correct? Then, now, compassionate appointment is not as a matter of right that you can claim. Are you following what I'm saying? Admittedly, in this case, till 2013, nothing happened. Now we are in 24. I'm going to dismiss this case.
Your Lordship, can be passed over on Thursday. Your Lordship, earlier the petitioner have also approached this honorable court in 3 WBC.
What happened?
So this honorable court has given a direction to consider petitioner's application.
Where is that order?
Annexure I. Page number 27.
Your pages and my pages are not matching. Page 27 is Annexure G. Yes, where is that? Yes, I've got it. 16/8/2018 order.
0604/2017, your lordship. And 16/8/08/2018 is subsequent
No, but
petition.
is this in your Muhammad Abdul Hafiz Chaudhry?
Yes, your lordship.
This is the same petitioner.
Yes, your lordship.
This counsel, there is a positive direction. Therefore, the respondents are directed to appoint him to one of the vacant posts of constable indicated in the letter if it falls under the quota of compassionate appointment, and if not, appoint him as soon as vacancy arises. Why haven't you complied with the court's order?
Lordship,
You didn't file any contempt.
sir, we have filed our contempt petition on COB 33 of
That is
2019.
pending.
It has been disposed, your lordship,
For what?
that no specific time limit has been granted in the writ petition, earlier writ
No, but
petition.
that doesn't mean that you will not comply with the direction of the court. Why should the petitioner file a second writ petition for executing the orders of this court? There is already an order of the court. If you have any problem, you go and file an appeal. I'm posting this matter on Thursday. Please give me your instructions as why the order of this court has not been complied.
Lordship, I have a humble submission. I have a personal engagement on Thursday, so.
All right,
if the-
Friday?
Yes, lordship.
Okay.
Lordship,
I can accommodate, but you see, Miss Counsel, it is a positive order, right?
lordship.
That you appoint. So give me the instructions, what is happening. This is a matter which has been pending from years.
Lordship, kindly allow me to read my affidavit.
Yes, yes.
Annexure C, page 10.
Yes.
Sir, I am directed to state that in compliance to honorable court order, the above cited case was referred to the state government. The Home Department in its reply,
Page.
page 10, Annexure C.
No, page 10 is your,
In my affidavit, lordship.
yeah, page 10 is some, it's paragraph 8B. This is the
I have
affidavit,
my first affidavit, lordship.
affidavit number
I
1, 2,
filed
3, 4, 5. Okay, I'm getting it. Yes, 10. Yes, the Home Department. Please
Lordship.
read.
To Muhammad Abdul Hafiz Chaudhry, sir, I am directed to state that in compliance to honorable High Court order, the above cited case was referred to the state government.
So he is not an indigenous inhabitant
Lordship.
and hence cannot be appointed.
Lordship.
Then why did you not file an appeal if it is not possible to comply with the direction of the courts? Anyway, you want to bring something, you said some documents you have.
Lordship,
Huh?
lordship, yes.
When? I'll post it on Monday then.
Lordship,
Okay.
lordship,
As prayed by MS Bishanu Kitan,
lordship.
let government advocate list this matter on Monday, so and so.
I would like.
For hearing, item number 21.
Your Lordship,
Yes.
Your Lordship, here the brief is handled by colleague and she's in this post today. So it may be listed after a week, Your Lordship.
Lordship, I am
As prayed for by MS
In the Holy Your Lordship.
so and so, counsel for the state government, list this matter
After a week, Your Lordship.
after a week on a date to be fixed by the registry.
Much obliged.
For hearing, item number 26.
Yes. 26. Regularization.
Yes, Lordship.
Yes, can it be disposed of by directing you to consider the case of the petitioner? Because it's a case of regularization for payment of pension.
This is the post regularization, Lordship. However, Lordship, there is a 22 or 22. There is one judgment, Lordship, the authority, Lordship. I would like to place that on record.
Lima.
Please.
Now you can switch off that fan.
Tell him.
Yes, what do you want to rely from here?
Lordship, similar matter was disposed of by the apex court, Lordship.
In favor of the petitioner or against the petitioner?
Lordship against the, in favor of, again, in favor of the respondent, Lordship, state respondent, Lordship. The state,
Are you aware of this decision?
the state has
Are
preferred,
you aware of this decision?
Lordship, is it Nishibi Achumi?
Lordship, yes. Lordship.
Yes.
Yes, Lordship, I'm aware.
Are you covered by that?
Lordship, if I'm not mistaken, that is a case of delay of 17 years. And on that basis, it was
Disposed of.
yeah, disposed of. I'm so sorry. So,
So you can distinguish.
yes, Lordship, because here, the husband of the petitioner.
All right, please read paragraph 7 and 8.
Paragraph 7, Lordship. Paragraph 7, having heard learned counsel for the state and considering the submissions met on behalf of the state, and having gone through the judgment and order passed by the learned single judge confirmed by the division bench, we are of the firm opinion that the High Court has committed a grave error in directing the appellant to regularize the services of the deceased employee 1 day prior to his date. 8. It is required to be noted that the deceased employee died in the year 2005. During his lifetime, he never claimed any regularization. That the respondent herein original writ petitioner, wife of the deceased employee, claimed the regularization after a period of 12 years from the date of the deceased employee. At the time of the date of the deceased employee, he was not entitled to regularization as he was much below in the list of the work charge employees whose services were to be regularized. Under the regularization policy, the services of the work charge employees were required to be regularized as per the seniority and as and when the vacancy arises.
So in this case, is there any regularization policy in the case in hand?
No, Lordship. Lordship, the state government has not framed any policy.
Because you see, this decision otherwise is in the context of that case.
Lord.
She is very right when she said that there has been a firstly the person had already died.
Lordship.
And secondly, at that time, he was not even qualified under the regularization policy because that there was a policy which as per seniority, and that exercise was done in 2009 after he was after he died in 2005.
Lordship.
He died in 2005. Regularization was done in 2009, and he claimed after 12 years. And the High Court, despite that, had granted regularization, which was interfered by the Supreme Court. So that is on the facts of that special case in the context. Decisions of apex court is always contextual. You cannot just say that it applies to any case, that it has to be understood in what context it has been given. Correct?
Lordship.
Now, in this case, yes.
Here, Lordship, the husband of the petitioner died in harness. He was in service while he died. And
when?
He died on 9/4/2019.
9/4/2019.
19. Yes, and this petition was filed.
While in service.
Yes, Lordship.
Yes.
And this petition was filed on.
Is any representation filed?
It was filed only after his death.
When? Where is that representation?
Annexure 6, page 22, Lordship. It was filed by.
Page 22. Yes.
Lordship. It was filed by the wife.
Has this representation been considered or acted upon?
No, Lordship.
It is still pending.
That's why we approached.
So I will dispose of this writ petition, directing respondents to consider the representation in accordance with law.
Lordship.
Lordship.
Okay.
Lordship.
That's item 26, right? Heard, MS?
Ubang Nanla, my name is not in the cost list, Lordship.
But I have to record your name, ma'am.
Ubang Nanla Longcha.
Please give it. And Mr.
Vijmomi.
N Mozovi or V?
Vijmomi.
V.
Vijmomi.
Lima, please take their names. Please give your names in a slip, because my private secretary is also from Gauhati. I don't want any spelling errors. By way of this petition, Lekha Bhargav, give it later. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking direction to regularize the service of who is the petitioner? Wife?
Wife.
Regularize the service of her husband, late SHULE at Shuli, in the post of W/C painter helper, posted under subdivisional officer within bracket SDO housing within bracket H, Wakha, Nagaland, with effect from 27/3/2023 to 9/4/2019, and consequential release of family pension and other benefits. Stop. To page 8 of Sailoba. MS so-and-so learned counsel for the petitioner submits that pursuant to the death of the petitioner's husband on 9/4/2019, the petitioner Ms. Counsel. Okay. The petitioner on 4/9/2019 filed an representation before the Engineer-in-Chief Public Works Department, Nagaland, Kohima, seeking regularization of the service of her husband in the post to which he was appointed as work charge painter helper under SDO PWD within bracket H subdivision Wakwa on temporary basis in the scale pay of rupees 800-18-890-20-1050-25-1475 per month, plus all other allowances. Stop. She further submits that the aforesaid representation having been not considered till date, having been not acted upon, the present writ petition had to be filed. Stop. Mr. So-and-so learned counsel for the state.
Lordship.
Your designation?
Junior government.
Learned junior government advocate fairly submits that he has no objection in the event the writ petition is disposed of with a direction to the state respondents to consider the said representation in accordance with law. Stop. In view of the aforesaid endorsements made by the learned counsels for the parties, this court is of the considered opinion that this writ petition can be disposed of in the interest of justice by directing the respondents to consider the representation of the petitioner dated 4/9/2019 in accordance with law within a period of 2 months from the date of receipt of the certified copy of the order. Stop. Ordered accordingly, disposed of.
For hearing, item number 27.
Pension. Yes.
Lordship, for this matter, my senior will lead me, so if it can be called up after break.
After break.
Yes, Lordship. Or after the hearing items are over.
Tomorrow?
Lordship.
Tomorrow is there a division bench?
Lordship, yes. tomorrow.
Thursday?
Lordship, Thursday I have personal
Friday?
difficulty, so.
Monday?
Monday, Lordship.
List again on Monday.
Obliged.
For hearing, item number 28.
May it please your lordship.
Hmm.
Your lordship, this is equal pay for equal work. Your lordship, the petitioners are Dobashis appointed under Waka district, and they are being paid the 1993 ROP when there has been 4 successive revision of pay over the years. So my lord,
as per the principles laid down in the Jagjit Singh case, if the petitioners can also be given the minimum pay
Which
scale in the
decision?
latest, Your Lordship.
Which decision you are relying?
Your Lordship, the main decision that I'm relying upon is the case of Jagjit Singh,
Please give a copy.
my lord.
You have not given the book list.
We have, Your Lordship.
Hmm?
Your Lordship, 2017, 1 ACC 148. Para 45, 44.2 to 44.6 and 58, Your Lordship. Why para 45 first? Is it 43 or 41?
What do you have to say? Can it be disposed of in the line of the decision of the apex court in the case of Jagjit Singh?
Lordship may kindly come to my affidavit in opposition
Or-
file on behalf of respondent. number
One sec,
five,
I'll
Lordship.
then, I was just simply trying to see
Lord.
if it can be disposed of. If you are
Lord.
going the merit, let me first examine this.
Lord.
Yes, which paragraph, Mr. Counsel?
Your Lordship, may I start from paragraph 44.2? That is page 209, my lord, if we are holding the same book,
209.
Your Lordship.
The problem with 209 is that the paper is half torn. Mr. Counsel,
My lord. May I give my copy to Your Lordship?
which para are you referring to?
Para 44.2 to 44.6, para 45 and para 58,
Let's see anyway.
my lord.
Para 42.14.
Para 44.2 to
Okay,
44.6.
All right, read.
May I read, my lord?
Yes.
In Surendra Singh case, this court held that the right of equal wages claimed by temporary employees emerged inter alia from Article 39 of the Constitution. The principle of equal pay for equal work was again applied where the subject employee had been appointed on temporary basis and the reference employee was born on the permanent establishment. The temporary employee was held entitled to wages drawn by an employee on the regular establishment. In this judgment, this court also took note of the fact that the above proposition was affirmed by a constitution bench of this court in DS Nagara case.
So basically, you have to first show that
Your Lord.
the work is equal.
Yes, my lord.
Because
Same
principle is
designation,
equal
performing the
pay
same
for
duty.
equal work.
My lord.
Simple designation will not do.
My
The
lord.
work, scope of work is also important,
Truly, Your Lordship.
right?
Your Lordship. So they are all dobashis, regular dobashis are getting the latest pay scale. Regular dobashis, dobashi.
What is this?
Dobashi is it's a term that was borrowed from the time of the British, dobasa, speaking two language,
Dobashi.
translators. Yes,
So this is the nature of the job is translator.
it was initially, Your Lordship, but now they actually they mend the customary courts under the district administration.
They are what? They mend.
They mend the customary courts, customary cases related to.
Are they presiding the cases?
Yes,
Are
Your
they
Lordship.
acting as a
In
presiding
fact,
officer?
yes, they are acting as
the
presiding officers
customary
in the
courts.
customary courts, my lord. So, Your Lordship, same designation, performing the same duty.
So here you all are you are holding the post of
Dobashi, DBs, Dobashis,
how do you spell it?
DOBASHI.
Dobashi.
Yes, Your
And
Lordship.
the pay scale that you seeking is of
The latest pay scale, Your Lordship, the minimum pay scale in the latest ROP,
equal pay.
Your Lordship.
So where this latest pay scale is of ROP,
ROP 2017.
this gives the pay scale to persons holding equivalent post.
Yes, Your Lordship.
Which is that post called?
Dobashi.
Dobashi.
Yes, Your Lordship.
All right. Then next para. Which is the next para
Yes, Your Lordship.
that you want to read?
44.3.
44.3 is half eaten.
Oh, I may be allowed to read, Your Lordship. In Bhagwan Das case, this court recorded that in a claim for equal wages, the duration of which an employee would remain or had remained engaged would not make any difference the duration for which an employee would remain or had remained engaged would not make any difference. So also the manner of selection and appointment would make no difference. And therefore, whether the selection was made on the basis of open competition or was limited to a cluster of villages was considered inconsequential insofar as the applicability for a principle is concerned. And likewise, whether the appointment was for a fixed limited duration 6 months or 1 year, or for an unlimited duration was also considered inconsequential insofar as the applicability of the principle of equal pay for equal work is concerned. It was held that a claim for equal wages would be sustainable where an employee is required to discharge similar duties and responsibilities as regular employees.
You are a regular employee.
No, we are not regular employees, Your Lordship, but we are paid a 1993 ROP, Your
So
Lordship.
you have been appointed as
Dobashi.
on a temporary basis.
Yes, Your Lordship.
You have not been regularized in now.
Yes, Your Lordship.
So therefore, you are claiming that you be paid
Yes, Your
equal
Lordship.
salary as that of a regularly appointed Dobashi.
Yes, my
Is
lord.
that your case?
That's
That
exactly
is
my
your
case,
case.
Your Lordship.
So I think 44.8 will also apply in
My lord.
state of UP versus Putilal,
Yes, Your Lordship.
isn't it?
Yes, Your
It
Lordship.
was held that a daily
True, Your
wager
Lordship.
discharging similar duties as those
My lord.
engaged on regular basis would be entitled to draw his wages at the minimum of the pay scale drawn by his
His counterpart.
counterpart
Yes, Your Lordship.
appointed on regular basis, but would not be entitled to any other allowances or increments.
My lord.
This is what you are seeking,
True, Your Lordship. My lord.
correct?
Your Lordship, in a
I
nutshell,
think,
just one sentence, Your
we
Lordship.
should, yes.
My lord. You know, the state has filed an affidavit stating that the commission for fixation of pay has the authority to fix the pay according to their own whims and fancies. The rule doesn't prescribe that, but they have misinterpreted the rule. So perhaps after the break, my brother would, my learned
All right, I shall
your
resume
colleague-
after
Yes, Your
lunch.
Lordship. My lord.
You get a SSC print, huh? If you have any problem in assessing the SSC, you can seek help from
Yes,
the junior counsel.
my lord. Now let's go to the appointment orders. Initial appointment order, election of Munla. Oh, petitioner number one. Initial appointment of the guy. Who was this petition filed? Thank you. Bless you. Go to the entire paragraph of 5. Okay, 44, 45, 58.
Yeah, please, Your Lordship. Your Lordship, I'm seeking your indulgence in mentioning item number 37.
Mentioning is done at 10:30, not at 2 o'clock. What is your prayer?
Your Lordship, here in item 37, Your Lordship, I'm yet to receive full instruction with regard to the
Item?
item 31 from the hearing list. I'm yet to receive full instruction with regard to creation of.
You are the petitioner.
Yes, my
Yes,
lord.
Your Lordship.
Here, my lord, the instruction is that
Stenographer, where's
the,
stenographer?
oh. Before the
Kohima?
stenographer comes, if my lord may kindly allow me to apprise the lordship. Now, my lord, this is a case to do with the functioning, the registry of the Nagaland State Consumer Commission, Dispute Redressal Commission. Here, my lord, not even
But
a single person.
report.
Yes, my lord.
That
Yes,
is
on
not
the basis of
considered.
that.
Your
Not yet
grievance
considered.
is that.
Yes, your lordship.
Non-consideration of the committee's report.
Yes, my lord. Not
Huh?
even a single post has been created thus far, your lordship.
Your Lordship, is under consideration, Your Lordship. The matter
How much
is.
time you need?
Your Lordship, the committee was set up to recommend the post. The committee has already given its recommendation, and this recommendation will sit before the MRC.
So then, can this matter not be disposed of with a direction that you complete the exercise within the 2 months from today?
Your Lordship, 2 months will be, if
That is possible, your
adequate
lordship.
time may be given, I have
That
no
is
objection.
possible, your lordship, because it's been years, my lord.
No point of keeping this matter pending. Since you are saying it is under consideration, you complete the exercise.
Your Lordship, since this matter would have to go with the MRC again, Your Lordship, after.
So whatever it has to be, you do it, there is a committee's report.
Yes, Your Lordship.
Now it is about the implementation of this committee report, and you are not saying that you will not be implementing it. That's not your stand.
Your Lordship, the cabinet will have to take a decision, so.
Let him take. I'm not coming in the way of the cabinet.
My lord.
I am only saying within 2 months you finish whatever is to be done.
3 months, Your Lordship.
All right, I'll make it 3 months. Give me 31.
Hearing item number 31. Correspondence, kindly give it.
So
to the
because
lordship.
on your last instruction that you had submitted appears that MRC has been constituted. All right, give.
On 8th of October, I have received these instructions.
So it has been forwarded to the chief secretary.
Yes, Your Lordship.
So I may record both of your
Your
instructions
Lordship,
and I
yes.
may say that since things are moving,
Yes, Your Lordship.
you finish it, isn't it?
My lord,
Item 31 for disposal, huh? Heard Mr. Joshua Sheki,
my lord,
learned counsel for the petitioner. Stop. Also heard MS
Inaholi, Your Lordship.
N Aholi.
Iholi.
Iholi.
Inaholi, Your Lordship.
Inoholi N
INAHOLI.
Inoholi. Learned
Junior government advocate.
junior government advocate for the state respondent. Stop. By this petition under Article 226 of the Constitution of India, comma, the petitioner is seeking
creation of post, my lord.
direction to the state respondents for creating 15 numbers of posts for registry establishment as per the Bagla Committee report of 2000. Inter alia will go out, huh? The case of the petitioner is that the petitioners are all employees of the Nagaland State Consumer Commission. And since inception of the commission in 2011, no regular appointment has been made. Stop. It is the specific case of the petitioner that despite the Bagla Committee report of 2000, recommending to all states to have staff strength depending on the number of cases, comma, no action has been taken by the state respondents till date. Stop. It is the further case of the petitioner that the committee recommended for having the registry staff strength to be not less than 15 for the states with less than 500 cases.
My lord,
However, till date, not even a single post has been created. Despite the 7 petitioners, out of which most of them have been serving the commission for years together, comma, their services have not been regularized till date.
my lord,
Accordingly, representations have been filed for compliance of the for compliance and implementation of the Bagla Committee report by creating post. However, the same having not been done till date, comma,
my lord.
the present writ petition has been filed. Stop. Mr. Sheki, learned counsel for the petitioner, submits that it is imperative for the state respondents to implement the Bagla Committee report, and non-implementation of the same has affected the petitioners irreparably. Stop. MS Inaholi, Learned Government Council, submits that in terms of the instruction received by letter dated 6/9/2024, the Deputy Secretary to the Government of Nagaland has informed her office as regards constitution of the Manpower Rationalization Committee within bracket MRC by notification dated 2/9/2024 to examine the actual number of posts required for the State Consumer Disputes Redressal Commission to start functioning, and that the committee have scheduled their first meeting on 11/9/2024. Stop. Today, when the matter was called, she further places the instruction dated 8/10/2024 received from the Undersecretary to the Government of Nagaland, whereby her office has been informed that recommendation of the committee constituted to recommend the actual number of posts required for State Consumer Disputes Redressal Commission to start functioning has been forwarded to Chief Secretary on 5/10/2024. Stop. A copy of the aforesaid instruction dated 8/10/2024 is kept on record and marked as X. Heard, perused. It appears that the grievance of the petitioner canvassed in this writ petition is the non-implementation of the Bagla Committee report. It further appears from the instructions placed by the Government Council that a committee being Manpower Rationalization Committee has been constituted.
Your Lordship, the Manpower Rationalization Committee has recommended a committee to be formed so that
Instruction placed appears that the Manpower Rationalization Committee has recommended constituting of a committee.
Yes, Your Lordship.
In order to examine the actual number of posts required for the State Consumer Disputes Redressal Committee to start functioning.
Commission.
Uh,
Redressal Commission.
Redressal Commission, Commission to start functioning. And the recommendation of the said committee has also been forwarded to the Chief Secretary for doing the needful. Stop. That being so, this court is of the considered view that the writ petition can be disposed of in the interest of justice by directing the state respondents to implement the Bagla Committee report within a period of 3 months from today, in accordance with law. Stop. Ordered accordingly, disposed of.
Lordship.
Yes.
Now, my lord. Item 28, my lord.
Yes.
Your lordship, may I take your lordships to the petitioner's appointment orders as well as the enhancement paid.
1 second.
My lord.
Table is small, no?
Yes.
May I take your lordship to annexure 1, page 29? This is the
Page
petitioner.
number?
29. Annexure 1. My lord, the type copy is at page 30. This is the petitioner number 1.
Is this the last matter on board? How many more are there? 33 and 35. Councils are there. You are in item number? Are you going to do the matter?
Yes.
Because this one might take time. That's why I'm asking.
But you did not give, the other party is from Dimapur. He has informed us that he will be doing it by way of missing.
Which one? Item?
135. If the matter is going to take time, then maybe I don't.
That is why. When do you want it?
Lordship, since I have some personal difficulty today, Lordship, if this matter can come up tomorrow. Lordship.
Which matter?
This matter, Lordship.
This matter means?
No.
Which matter?
Item
29.
Item
This matter.
The matter which I am
Lordship.
hearing.
Lordship.
Item 28.
Lordship.
You want it when?
Tomorrow, Lordship.
Tomorrow, your lordship, is a Wednesday.
And on
Thursday?
Thursday, Lordship.
All right.
Lordship.
Then I'll have it on Thursday.
Lordship.
But I'm not going to adjourn it beyond
Lordship,
Thursday.
Lordship, on Thursday, Lordship, as a fixed item, Lordship.
Can my lord kindly put it in the?
Forget, it will make no sense then. If he wants
Lordship.
accommodation, I shall have it on Thursday.
Lordship.
My lord.
As prayed for, list this matter again on Thursday.
I love it.
Oblige you, lordship.
This is that case law. No? Put this in the file. This you can return.
For hearing, item number 33.
33. None appears for the petitioner. None appears for the parties. List after 2 weeks on a date to be fixed by the registry.
For hearing, item number 35.
I am for the claimant. Your lordship, the appeal has been preferred by the company.
Yes, where is the appellant?
Company counsel.
Lordship, I'm appearing through video conference, Lordship, due to some disturbance on the road.
Mr. Devnath, yes.
I'm unable to present myself before your Lordship physically today.
You want it on another date, Mr. Devnath?
Lordship, I'm ready, and if your Lordship may allow me to take up the hearing, I can do that also.
All right.
Lordship.
You are for the insurance company?
Lordship, I'm for the appealant insurance company, Lordship.
Yes.
Lordship, if I may take your Lordship to the brief facts of the case.
Yes.
Lordship, the respondent number 1 as claimant, Lordship, has filed the claim petition under section 166 of the MV Act, read with section 140.
Your voice is not very clear.
Lordship, am I audible now, Lordship?
Yes.
Lordship. They filed the claim case before the Motor Accident Claim Tribunal, Mokchung, as MSC case number 18 of 2019, claiming compensation of rupees 32,25,000 on account of the alleged injuries sustained by the claimant in a road traffic accident at Gauhati, Lordship. And the insurance company has entered appearance and denied its liability, Lordship, by filing the written statement. Lordship, your Lordship will consider that the learned tribunal, while taking up the case, Lordship, has overlooked one of the vital aspects of the case, that in the claim petition, the claimant has averred that she is a businesswoman and is earning a sum of rupees 20,000 from her business, as stated at paragraph number 4 of the claim petition. At paragraph number 4. However, Lordship, in the PWS, the same claimant has stated that she's a government employee employed under the wildlife PCCF Gauhati. and has a salary of 45,000 something, Lordship.
The claimant is a government employee.
Lordship, as per the claimant's PWS, Lordship. However, in the claim case, she has averred that she is a businesswoman, Lordship, and she is earning a sum of rupees 20,000 per month, which is totally false, Lordship. However, the learned tribunal has overlooked this.
On what basis are you saying that this is not right? The evidence, something has come out.
Lordship, in the evidence, she has averred that she is a government employee. And in the claim petition, Lordship, she has averred that she is a businesswoman. However, no income details has been with regard to the garment business has been adduced by the claimant.
Mr. Devnath, just give me a minute.
Lordship.
The screen is actually kept in a space where I'm not being able to see you.
Lordship.
Just give me a moment.
Lordship.
And can you increase the video? Yes, Mr. Devnath.
Lordship. Lordship, if I may take your Lordship to the claim petition of the claimant, Lordship, in the LCR, Lordship.
LCR, is there?
Yes, it has come, Lordship.
Yes.
Lordship, the second page of the claim petition, if your Lordship may turn up to the second page of the claim petition at internal page number 2, Lordship.
Yes.
At serial number 4.
Yes.
It speaks that occupation of the person injured / dead, garment business, Lordship.
Dealing assistant government servant.
Lordship, but as okay. But as per my file, Lordship, it is like garment business, Lordship.
No, this is the claim, right? MAC case number 18 of 19.
Yes, 18 of 19, Lordship.
Correct.
Lordship.
And at page 2, the details, particulars of the injury deceased.
Lordship.
Number 4, occupation of person injured / dead. Dealing assistant government servant.
Okay, but then Lordship, as per my my copy, Lordship, it is stated as garment.
Devnath, you do one thing. When can you be physically present? Day after tomorrow?
Lordship, on 8th, Lordship.
So I'm fixing it on 8 or after 8. You can, in the meantime, you have a look at the LCR, the trial court records.
Lordship.
Because this is not matching with your claim that you're holding. So just verify it.
Lordship.
Okay.
Lordship.
Posted when? On 8th?
Lordship.
It appears that the details of the particulars of the injured stroke deceased in respect of, the occupation of the person injured dead as contained in the claim is not matching with the claim petition available with the respondent stroke appellant. Let Mr. V. Devnath, Learned Counsel for the appellant, verify the trial court records before the next date of listing. Accordingly, list the matter on 8/11/2024.
Naturally.
Obliged.